Yes, no, absolutely, that's noted, and I will do that.
Because from my perspective, in my reading of that order, this is not a question of if the permit will be issued, but how the permit will be issued, given the mitigation. It's not a take another look at it, fellas and ladies, and let me know what you think. It's issue the permit, I'll let you decide mitigation. That's the judge's order.
Right, that's an absolutely correct characterization. So the only impediment to that would be, were we to file a notice of appeal and successfully argue that this was a case of substituted judgment by the trial judge.
Which you and I had discussed offline. There's an argument to be made for substituted judgment from the body. Obviously, I was in the non-prevailing party during that vote in the SPGA, but I can see the argument that could be made relative to the judges, some of the judges' findings, which were different than my remembrance of the events of that hearing, those hearings. But that would bring up my second concern. Are we nominal defendants, in your opinion, in this action, the SPGA?
Yes, not just in my opinion, you are nominal.
So in the instances in which we're nominal defendants, meaning we're named, but we're really not the ones that...
Your official capacity.
Right, in our official capacity. When we're nominal defendants, it's then incumbent upon the executive to defend the court cases and make decisions in litigation.
Well, SPGA is different. It's up to the body whether you feel we should appeal it or, I mean, it's your permit. Your permit denial, actually, that's in question. So it really would be up to this body. That was one of the issues I ran into some time ago, and I think most people are aware. Councilor McNamee and I were friends as well as being professional colleagues, so I can invoke his name and blame him for something, even though he's not here to defend himself. But he had some questions during the first round of CMAR where he was concerned about actions I took that I thought were appropriate and in the interest of the body, but he challenged it a bit. So since that time, I have brought things back to this body, even to the point of having you read decisions before they're signed and endorsed by the clerk. I give you the opportunity to review them to make sure you're satisfied with the written decision. So it really is this permit granting authority, but I'm very happy to provide as much advice and thoughts and do so publicly as you may need.
So I would request a legal opinion from you or a memo from you, a letter from you, relative to the legal basis for appeal and why that would be in the best interest of the SPGA. Because after I read that decision from the judge, well, you can see some argument on the other side, from your perspective, on the other side of what the judge's opinion is. I look at the applicant, and from that perspective, I would imagine they want to take action on the judge's decision, which is cut and dry, it's issued a permit. So to contemplate an appeal, even if we have no intention of moving forward with it, is stopping the clock on a property that the applicant's been paying taxes on for a number of years while this has been, and I don't know that a single abatement has been given on any of the property taxes he's been paying a multi-million-dollar property.
The docket number is 09, so it's been around for a while.
Right, so I have some concern. I'll tell you, I have some concern as someone who sits on the SPGA that we're not scheduling the meeting to conform with the judge's ruling to issue the permit with conditions, that we're not just discussing the mitigation and the issuance of the permit, that we're contemplating an appeal. And I certainly wouldn't want, I speak for myself alone, I wouldn't want to say, I won't take a vote as an SPGA member to file a notice of appeal for the purpose of slowing the clock down and giving us more time. This thing has been kicking around like a bad penny for too long. We need to make a decision and move forward. There seems to me to be only one issue here. It's not if the permit gets granted, but how it gets granted with what type of mitigation. So I would like to see us resolve this matter at the next meeting in the SPGA rather than file a notice of appeal, negotiate with them, kick the can down the road. To me, it seems a little like rearranging the deck chairs on the Titanic. You know, this is the thing's decided here. It is what it is. The judge says remand the case back to us, to the SPGA, to issue the permit, not to decide whether or not to issue the permit. We can't get any more cut and dry than that. The only thing we can consider is whether or not to issue mitigation. So I would hope that in the interest of conformance with the judge's ruling, we would be moving in an expeditious process. And an
I'm not
expeditious fashion
implying
with the SPGA. Yeah, okay.
Yeah, I'm not implying we kick cans down the road or delay anything. What I'm saying is file a notice of appeal, which does nothing as far as impacting what this body might do, and then negotiate. But I'm happy to go further with the discussion, but if any of you read that decision, it's very concerning, and I think much of it's not warranted.
I agree with you. I have concerns. I discussed that with Will.
So I don't like to, I just want the body to be aware that, does a decision like this stand? You know, he talks about one of the, something called a travel time delay study, and says that, you know, he talks about that fully credits the applicant's traffic engineer. And during the course of the trial, during the travel time delay study, I cross-examined the engineer, and he acknowledged during my cross-examination, after he provided copies of it, that there was a problem with the numbers. They had guys out there who were saying there were red lights at Chapman Street and Bass Street, and they were stopped at the red light for a certain period of time and then proceeded through, and there are no red lights there. So the underlying data that this engineer worked with was not accurate, and that came out of the trial. Well, how then do you credit the engineer fully, as he did? That's, to me, is a mistake, and it's a clear error. And that, as you know, this is trial court level, and it's why appeals courts are in business in the Commonwealth. The primary reason for overturning the zoning decision is substituted judgment. And I can understand why the judge had some of the concerns he did. But some of the fact-finding that occurred here is troubling, and that's, I just want to call it to the attention of the body. I'd ask you to read the decision again. And I agree with you that, and I said this earlier, that moving forward is the way we have to do it, but in a manner that I think is appropriate. And I'm just looking to protect the interests of the body relative to this decision, but continue to move forward.
So is there any reason
not
why
merely,
we can't?
I was just going to say, I'm not merely trying to proliferate what has gone on here. I fully agree with you. And I think that if that's the will of this body, I know the mayor is prepared to provide assistance and to work going forward. But, you know, the concerns all along with traffic and the impacts wasn't animus. So that's what we have to work with.
The way I see it, perhaps I'm wrong, there's three options at the next SPGA meeting. There's three options that the body has. Grant the permit as instructed in the remand without mitigation, if we so choose. Grant the permit with mitigation, and file a notice of appeal. Those are the only three options that would be available to us at the next SPGA meeting.
Right, and 2 and 3 can both happen and are not usually inconsistent. They're in fact usually consistent. That happens all the time. The parties file a notice of appeal and then they talk. And that is absolutely what I think is the best course here.
So
that's why we're having this public discussion. The president in whose ward this proposed operation would be located has had this discussion with me. And, you know, so we understand or agree.
Is there any reason why we can't have all options available to us fully vetted by the time of the next SPGA meeting? So on the appeal, we have a letter from you or a memo from you as to why it would make sense to appeal, what the basis of that opinion is. We all value your opinion as expressed tonight and in an earlier vote. So you give us your opinion as to why an appeal would be the best course of action if you think it is. And also have concurrently the planning department offer up some ideas, recommendations for mitigation so that when we meet, there's no reason for delaying whatever action the body chooses to take at that time.
That's correct, and there is no reason. I'd be happy to ask Mr. Murray, the legal representative, CMAR, perhaps any CMAR representatives who wish to be present, to come at that time, if that seems appropriate.
Okay.
Just to look at options.
Thank you.
Thank you. Council. Thank you, Madam President. Just as a follow-up to the judges, the mitigation, does that then get approved by the judge? The mitigation, does that go back to the judge for approval?
Well, it would only go back to the judge if the SPGA issues the permit, we're done. If we, and if we do so with mitigation, then we'd be all set. I'm presuming that if we were to go forward in that manner, that the mitigation will be agreed upon. We would only go back to the judge if this body felt strongly that there were certain mitigation measures that were necessary and appropriate, and CMAR felt equally strongly that, that's beyond the pale, and then we present it to the judge.
So hypothetically, I think there's not really an opportunity at that location to get traffic over the train tracks, right? There's another bridge onto the Port Ave from that area, from another area. Getting traffic, that wouldn't be a exorbitant
Again, I
expense.
think this level of discussion, when we get back, this is the thing that concerns me, is that discussing the merits at this particular point in time, that would be discussion better preserved within the special granting authority session.
Right.
Because
Right, and I don't know if that's what
I'm just trying to get a scope on the mitigation, so that would be something that would be exorbitant.
Well, I think
Most
that,
likely.
again, I think that it's critical, because there's other things within that judgment that are more technical in nature, where we slipped up, for lack of a better term, in terms of even if the intent wasn't, even if it wasn't pretext, it could have the appearance of pretext. And that's one of the things I just think we need to be very conscious of, concerned about. That if we're going to have that discussion, we announce an SPGA meeting, we set up that time, and we have the discussion.
The point of this, though, is to have you be informed, because unfortunately, logistically, it's difficult for this body to act expeditiously.
No, but
And so I just wanted to get things like this aired so everyone's aware of what.
I agree, but the point is, we have 1, 2, 3, and potentially 4 new people who will be sitting in the future. If we start making statements outside the context of SPGA about the nature of traffic or the different things, I'm just very concerned about that. I think we're better off.
I don't think we're doing that. And I would make sure we don't do that. I agree with you.
Almost, I was just trying to put it towards mitigation, if you're throwing something out there, and what's the judge's role at that point? Does it need their approval with what we have, or as long as the applicant's agreeable, we're good to go? If the applicant's disagreeable, back to the judge we go?
Correct. If we can't agree on something, we go back to the judge. That's right. But I would anticipate that if we get on that road, it would probably be a productive matter.
Thank you,
All right.
Mr.
No,
Thank you. All right, moving on, approval of previous meeting? All right, to the approval of previous meeting minutes from the meeting of December 21st, 2015. Is there a motion to accept the minutes? Motion's been made and seconded by Councilor Crowe. All those in favor?
Aye.
Aye, the ayes have it. Communications?
I have several, Madam President. The first communication I have is dated December 16th. It's from Thomas Tinlin, T-A-N-L-A-N, who's the Administrator of Mass Department of Highways, relative to the noise barriers in West Quincy. My suggestion is to file it with new order, and I'll distribute it. The second one is from, on the same subject, it's from Senator Keenan, Representative Ayers and Chan, relative to the mailing they did on January 4th to the West Quincy neighborhood. I'd like to file that. I'd like to suggest we file that with tonight's law in terms of resolution. And the last one is another letter from Administrator Tidland to Senator Keenan, which he approved with the fact. So with everyone's permission, I'd like to file those with that law.
All right, thank you.
The next 8 are the newest in the first graphics from me here. The first one's from Council Crowell, add a handicap parking space at 56 Burns Ave.
Ordinance